Thumbs up mean green arrow. Good evening. It's Thursday, July 18th, 2024 at 6 p.m. This is the City of Franklin Plan Commission meeting. Mr. Martinez, will you please take the roll call?
Mayor Nelson,
Here.
Commissioner Shogo,
Here.
Commissioner Haley,
Here.
City Engineer Morrow,
Here.
Alderwoman Day is excused, Commissioner Leon is excused, and Commissioner Specht is excused.
Thank you. Let's please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Item B, approval of minutes. Approval of the regular meeting minutes for June 20th, 2024. Is there a motion?
Move approval.
Second.
We have a first and a second. Any further discussion? What? Okay, thank you, Counselor. Just so anybody knows that the chair will be voting tonight to complete the quorum. All in favor?
Aye.
Aye. No opposed. Motion carries. Item C, going to the public hearing business matters. The first one is Regulo. Martinez, if you would, please, sir.
Thank you. Good evening. This is a text amendment proposed by staff to update the UDO, Unified Development Ordinance, fee schedule. This proposal has been presented before to the Plan Commission for feedback, so that feedback has been incorporated into the proposed ordinance, and this is the meeting for the public hearing that is required for text amendments. So I will go to the proposed major changes to the fee schedule. So we have like 5 different changes to the fee schedule. The first is to adjust for inflation. That will apply to most of the application types. You see the table in the screen. It's kind of hard to read, but you have the full table in the report. So second change is to increase filing fees over the application, over the inflation rate, for applications that staff consider that are important city policies, like the zoning map and the comprehensive master plan. So you can see that these type of applications are increased over the inflation rate. Third change is to have a developer's deposit for 2 applications, the Plan Development District and the subdivision preliminary plats. That was added based on feedback received from the Plan Commission, but it was not added to all of the application because that will pose like administrative burden to track the developer's deposit and make things complicated. So with the only for the PDD and preliminary plat, there are applications that are like 2 or 3 per year that will allow to kind of be more efficient on tracking the developer's deposit. The other change was a new fee for easements. We currently we don't charge a fee for easements, but that requires a lot of staff hours to review the easements, not only from the city development department, also engineering department that we send to review, and also for city attorney that we send the easements for review, and then we need to present the easement before the common council. So we're proposing to have a fee of $200 for easements. And the other change is to have a category for when it's 1 parcel residential, for floodplain land use permits, and also for rezonings. That was based on feedback from the Plan Commission. Okay, so those are the major changes. These changes are proposed based on a comparison that staff did based on other communities of similar size. So for example, the Comprehensive Master Plan Amendment, City of Franklin has the lowest of when we compare to other communities. So that's why we're proposing an increase that is over the inflation rate. Another example for final plats, most communities have what they call developer's deposit or review escrow or to charge for additional hours. So we were not proposing that. That's why we are now recommending to have the developer's deposit for plat applications. We can also see that for text amendments, variances, City of Franklin has the lowest fee. That's why for text amendment, we're proposing an increase over the inflation rate. And for site plan, it looks like our fees higher than other communities, but other communities, like for example, Oak Creek, they charge separately for landscape and lighting plans. Then if we add that to the fee, then that's why we are proposing to increase the site plan just with the inflation rate. Okay, those are the major changes proposed. I have the public hearing notice, and I'm happy to answer any questions.
Any questions at this point? Looking at the list here in order. Any questions from the commission at this point? Okay, if you want to read the notice then, sir.
Notice of public hearing, City of Franklin Plan Commission, meeting date, Thursday, July 18, 2024 at 6 p.m. at the Common Council Chambers at Franklin City Hall, 9229 West Loomis Road, Franklin, Wisconsin. Text amendment proposed by City of Franklin, Department of City Development, and that applies citywide. Proposal, the ordinance to amend the City of Franklin Unified Development Ordinance text in Section 1590-401, Administrative Fees, Section 1590-401A, Fee Schedule, to increase the zoning and land division application fees and to provide for requiring a developer's deposit for new plan development district and preliminary plat applications. This public hearing is being held pursuant to the requirement of Section 6223-72 of the Wisconsin Statutes and Division 1590-200 of the City of Franklin Unified Development Ordinance. The application and all supporting materials are available for review and may be obtained from the City Council by way of request to the Department of City Development. The public is invited to attend the public hearing and to provide input. The proposed draft ordinance is subject to revisions following public hearing and the further consideration by the Plan Commission and the City of Franklin Common Council.
Thank you. At this time, we'll open the public hearing. Any citizen wishing to speak, please approach the podium. State your name and address for the record. Going once. Going twice. We will now close. I have official time closing at 6:08. Thank you, Counselor. 6:08 open, 6:08 closed per the bulletin of City Attorney Wesolowski. All right. Any questions at this point from the commission again? So to read a motion?
Sure. An ordinance to amend the Unified Development Ordinance text in Section 1590-401, Administrative Fees, Section 1590-401A, Fee Schedule, to increase the zoning and land division application fees and to provide for requiring a developer's deposit for plan development districts and preliminary plat applications, subject to technical corrections by staff.
Do I hear a motion?
That motion.
We have a first.
Second?
We have a second by Mr. Haley. See no further discussion. All those in favor?
Aye.
Aye.
Any opposed? Ayes have it. Motion carries. Going on to C2. Marion? It's loud and clear, actually.
Oh.
Oh, it was.
Are you sure?
There's buttons being pushed. I don't know.
Okay. Thank you, Mayor. So this item is a natural resource special exception for property located at 11027 South 27th Street and the property immediately to the south of that, which is addressed at 0 West South County Line Road. There is a request for approval of impacts to wetland buffer and setback and also for approval to floodplain. I want to briefly canvass what is protected by our ordinances so that you have a clear understanding of what your purview is here and so that there's no confusion about what is being discussed. So you are a recommending body to the Common Council. Environmental Commission has already made a recommendation on this item. But broadly speaking, you are reviewing for conformance to the requirements of UDO Part 4, the Natural Resource Protection Standards, and the Natural Resource Special Exception Process, which is 15-10 of the Unified Development Ordinance. All natural resources in Franklin are protected by the UDO and those categories, and how we review for that is what's called a Natural Resource Protection Plan. So this is an example of one. There is one in your packet for the property being discussed, but this is Coatmeyer Lake, so you can see here that there are a number of natural resources protected. We protect all water resources, so wetlands, wetland buffer, wetland setback, rivers, lakes, streams, you name it. That is 100% protection level. And any impact to those requires a natural resource special exception for a permanent impact. In the case of wetland setbacks, you may restore them and not require that process, but broadly speaking, if you touch water, it needs an NRSE. We do also protect natural resources such as trees and steep slopes. There are steep slopes on the property being discussed this evening, but they are artificially made as a result of fill and not part of the discussion. Just for future reference, that is sometimes part of this discussion is impacts to woodlands and to steep slopes, which are protected. So this is the table that is in the ordinance with protection levels based on the zoning classification of the site. Agricultural, residential, and non-residential properties have slightly different standards in terms of what may or may not be mitigated, but the protection rates don't vary based on the zoning classification. The property in question is zoned PDD 39. Broadly speaking, that's a non-residential zoning classification. It's a planned development district. I would consider it akin to M1 zoning. The application you're reviewing this evening is what's called a natural resource special exception. It's required to be permitted to impact any natural resource that is protected by the table we just discussed. It's also regulated by UDO 15-10. Basically what that ordinance is the variance process, which you must go through in order to request the exception. So it is quite a lengthy process. We really strongly encourage developers to avoid the process if possible, because there are time consequences, cost consequences, as well as the obvious environmental consequences to these kinds of impacts. And Franklin has taken the protection of natural resources very seriously over their lifetime as a city. So an NRSE requires review by Environmental Commission, and they provide a recommendation to both you and Common Council, which was included in your packet, and I'll discuss the details of this specific example in a minute, but it kind of goes with, there's a set of ordinance requirements under that 15-10. We're looking at certain categories of natural resources, types of impacts, and also the rationale for the impact. So was this impact undertaken because, you know, there was no other way to design the site? Was it not? It can only be approved by Common Council. So again, you are a recommending body. There are some things that Plan Commission does have control over, and one of those things is the requiring or not of financial sureties for restoration work. So you have the ability to say, yes, we should require a bond or some other form of financial surety for restoration. What that typically, or for restoration or for mitigation, which both of those things are to take natural resources, and we have a requirement that you replace the natural resources elsewhere on the site. If you impact something in a permanent way, otherwise you can request to do it in other locations, and Plan Commission can allow that. They are also the body that makes that decision of whether or not off-site mitigation would be allowed. So it's bonding, the location of mitigation, which is not applicable in this particular example, but often is the case, like how much mitigation and where it goes. And those are the two things that Plan Commission, your decision on those items is final. Common Council may then be the final decision maker in terms of approval of the overall natural resource special exception, the scope of it, et cetera. And they adopt what's called a standards, findings, and decision, which is also provided in your packet. It's similar to the Environmental Commission recommendation, but a little bit less detailed. So the applicant has the burden of proof to show that their request is reasonable. The questions that are asked about alternatives, et cetera, are something that is modeled after the DNR's own work around wetlands. And so that current set of requirements in the ordinance says like how else could you design this? There are also cases where an NRSC is required for what's effectively an enforcement case where a natural resource has already been impacted and there must be a resolution to that in order to comply with our ordinances. So in this particular case, the applicant has placed fill in wetland buffers. I'll get to the details in a moment, but that is another example. We do see some of those NRSCs for restoration work. So in this particular case, the site we're talking about is the Fox Glen site. So some of you may be familiar with this. It's the location of the former Golf Dome. It was previously farmed, and I did provide a general site history for you in the staff report, but it is in the most southwest corner or southeast corner of the city, located in PDD 39. The applicant's request is to allow for impacts to wetland buffer and setback as a result of stockpiling of soils and placement of fills. There are also impacts to floodplain, which I'll discuss during the report, but the request tonight is to also allow for this NRSC to canvass the current existing conditions so that the applicants can then proceed through their FEMA requirements in order to obtain both local and federal approval of those impacts. So the site was historically farmed. A stormwater detention and golf facility were constructed in 1999 and then demolished in 2018 and 2019. There were construction and batch plant temporary uses granted. The concrete batch plant was actually related to the redevelopment of Elm Road and the interchange for that. And then there was a continuation of the use after the expiration of that temporary use approval. This resulted in complaints to engineering and planning, which are still open. And the DNR also engaged in enforcement because of some of the impacts potentially to wetlands. So Plan Commission issued a temporary use, effectively a stay of enforcement, while the applicant seeks this approval. And so we come to the actual request itself. There are steep slopes present on site. And the applicant is requesting, those are man-made though, and the applicant is requesting impacts to 31,629 square feet of wetland buffer and 19,784 square feet of wetland buffer, first on 11027 South 27th Street and the second on West South County Line Road. So the temporary use was granted on May 9th, 2024, and that's appended here in your packet. So just to walk through what's present on the site, this way is north, 27th Street, South County Line Road, the footprint of the previous Golf Dome and its related stormwater pond. So this is considered an artificial wetland and was filled with permits. There was a temporary use granted for a stockpile, which is located just to the north, and for the related impacts to that. And there are steep slopes on site that were artificially created. So the wetland is roughly here. Let's see if I have, yeah. So, and you have seen this previously as part of your temporary use request. So the wetland wraps around that filled area, and there are impacts to wetland buffer and also to setbacks. So the applicant is proposing to restore those impacts and to put plantings there that are appropriate for the conditions of the site. During review of the NRSC application, it was also determined that there have been changes to the FEMA floodplain because the topography on site does not match with what are called federal insurance rate maps issued by FEMA. So this is a site plan drawing from the original Golf Dome with the grade change in it. It does not currently match with the firm. It would appear that they obtained approval of a site plan with this topography in the site plan, but it's not clear that there was express grant of that change to the firm. And either way, an amendment to the map must be requested from FEMA in order to allow for this to condition to persist. So the applicant will have to work with us to resolve the firm map. So the way that I've worded the conditions related to that in your recommendation to Common Council is that if it's found that the applicant did their due diligence and that they that the topography changes within the firm are within basically an approval from the city, then the NRSE will effectively provide a grant of local approval, so they won't have to go back and do the NRSE in order to obtain approval. So if you imagine that this were a request that was being made brand new today, they would be required to do a land use permit, a natural resource special exception, and then also do the letter of map change or letter of map amendment with FEMA. So in order to get right with the city, they are now asking for approval of this floodplain impact, and they'll still have to do the land use permit and the LOMA. So, however, if it is found that they need to do something dramatic in order to allow for these grade changes, such as provide compensatory storage, which is something that FEMA will occasionally require, so that when you're impacting a floodplain, part of what occurs is an evaluation of whether or not it will change the floodplain for other properties. So if you raise the floodplain on other properties over a certain amount, then you're required to compensate for that on your site by providing what's called compensatory storage so that you're not causing increase in the floodplain elsewhere. So if something like that were to occur as FEMA is reviewing it, we don't have the information in front of us today to determine whether or not that is likely. But if they were to say you need to do compensatory storage or somehow otherwise come back and alter the floodplain, we would expect them to come back for another NRSE because it would be a change that the local body had not reviewed. So I'm trying to make that clear within the conditions that are there, basically that you're granting an NRSE for the existing condition of the floodplain, as well as for the restoration of natural resource impacts to wetland buffer. And then there are additional recommended conditions that the applicant provide maintenance information and guarantees and proposed restoration plans. Typically with a development proposal, this would occur on a landscape plan. They can use their NRPP or another drawing to describe the restoration and then provide guarantees here. The Environmental Commission specifically requested the phrasing of this following condition that the applicant shall provide for a diverse native seed mix, including short and long-stemmed grasses and forbs to be planted in restoration areas. So it's common that they make those kinds of recommendations with their area of expertise. And the seed mix provided was a fairly generic sort of stormwater mix with native plants. They requested that there be more diversity within the seed types. They also requested that clarity be provided on the following two conditions. And this is a recommended condition that once restoration is complete, the applicant shall install construction fencing to protect wetland buffer and setback from further encroachments during fill removal work and remove the construction fencing when work is complete. So they wanted to be explicit about removal of the fencing. And also that the applicant shall place boulders, fencing, or other permanent boundary in such a way that the wetland buffer cannot be encroached or mowed after completion of restoration. So we do not allow mowing within the wetland buffer in Franklin. And unfortunately, that's something that kind of, if there's no boundary marked, is easy to overlook. So we would require some kind of marking to prevent further encroachments in future. What that looks like could be pretty flexible. In some cases it's been boulders, in some cases it's been fences. If you, the Plan Commission, have a recommendation about that, it's certainly appropriate to make that today. With that, I can read the public hearing. The applicants are here and have some comments and requests of their own, but should I read the public hearing first, or?
According to the list presented by the city attorney, the applicants would come up at the table first, make their comments or whatever, and then we would ask questions of them at that time, and then we would go into the public hearing, and then the questions too.
Perfect. Thank you, Mayor.
Because what it says is first.
We're good. So
Okay.
we're gonna go this way. How about this? The chair will make the decision. So what we're gonna do is, folks, if you're here for this, if the applicants, thank you, sir. What would I do without you? Please come up here to the front of the table. We're going to make sure that the mics are on if you wish to say a few words. If not, we're going to go into the public hearing. Welcome right up here. We're just going to make sure that those, oh, one lit up.
Testing, test, test.
Yeah, pull it right towards you.
Hello.
Excellent.
All good.
I'm not sure about that one, though.
Names and addresses, please.
Yep.
But we're going to get, yes, so please state your name and business address for the record, please.
Sure. Matt Carey with Pinnacle Engineering Group, civil engineer helping out with the project. You're at 20725 Watertown Road in Brookfield.
Sam Schultz with Von Briesen and Roper. We're at 411 East Wisconsin Ave in Milwaukee.
Thank you very much. Good evening and welcome.
Thanks.
So you can steer your ship here and let you,
Sure. No,
Marion explained it wonderfully, so.
Yep. No, I think, yeah, she answered and basically laid it out pretty well. It was a great summary there. Following up from the environmental committee's meeting that we had last month, there were just a few clarification things on 4 out of the 9 conditions that we noted in the draft recommendation letter to council. I just didn't know if now is the right opportunity to express that, or if that's something that should be discussed separately with staff after tonight.
Marion, what are your thoughts? I have my thoughts.
So why don't you put your questions forward to the commissioner? I can give you feedback on what staff thinks.
My
about
thoughts exactly. If you got
Sure.
something, bring it, and we'll,
Okay. Yeah, and if we just step through them one by one, if that's okay. There's 4. The first one was, I think you and I had some dialogue on this already, but the number 1, which pertains to a conservation easement being set, that's totally understood. However, there is the potential for a future development following up after this remediation work, where grading would again be most likely necessary within that area, and placing a conservation easement within that now would greatly restrict and some prohibit in some form or fashion, and I guess just make it a little bit harder to get through the process down the road. So I think, Marion, if you recall, there was some email correspondence about that conservation easement would be put in place, not now, but in the future.
That's correct. So the current circumstances on this site are, this is an enforcement case which is being resolved in terms of the existing violation on this site. Typically, when we require conservation easements, it's at the time of a land division or a site plan, which is not what's occurring at this time. There's not a development proposal that is clearly in place, but there is a horizon of potential development. It would be effectively a duplication to require a conservation easement now that would then later require an NRSC to alter if there is a needed impact. So it's possible that the future development will need to have a natural resource special exception based on the proposals that I've seen to date. But when we're evaluating this request, I don't think it's necessary at this step, because we will be requiring conservation easements in future that will better align with the development of the site. So I'm happy to take direction from Plan Commission and from Common Council about that, but my personal interpretation is it's not necessary at this time.
not necessary is wonderful. Number 2?
Yep. She touched on the floodplain. Again, just going back in time, it was 1999, like Marion mentioned, when the Golf Dome facility was constructed. The ownership of Fox Glen did not take over that property until 2004, so it did occur after that. From everything on our team and the ownership side on Fox Glen, they've pretty much exhausted all options to see, if any approvals did exist from FEMA at that point. And I know just from own personal experience that usually the city, and I know everyone here tonight wasn't probably involved with that approval at the time, obviously, but the city would be the driving factor if this needs to get elevated to FEMA at that time. And I don't know if the city has exhausted all their, I'm guessing you have probably, or not, I don't know, has exhausted all your avenues to see if there's any more documentation of an approval from that time period.
So there is no documentation and no approval received from FEMA for the floodplain impacts. It will require a LOMA in order to be accepted as the site condition. And that process does have to go through the city. It would appear that a site plan approval with the floodplain depicted was issued in 1999. It's not clear to what extent the floodplain was evaluated beyond the use. So parking lots, et cetera, are typically allowed uses, but still require a level of review. So you can put a parking lot in a floodplain, but you have to go through the review process in order to do that. And that separate review of the floodplain did not occur. So, or at least we haven't found it yet. So I have not quite exhausted all of the files at the city's disposal, and I apologize, I was on vacation this last bit of this week, but it seems like the site plan was granted and then the city did not do some portion of the due diligence, or the applicant did not. So either way, it doesn't change what's required at present. So when we will work with the applicant in order to resolve that. So again, I've worded the conditions related to the floodplain approvals in such a way as to make it possible for them to proceed with the existing condition, in the hope that, if there's future, it's also likely that the future development may require floodplain impacts as well. So
Aware of that?
yeah.
That was brought up last month as well.
Okay.
Again, I think we wanted to state for the record that, obviously anything that goes to FEMA takes a lot of time.
Yep.
It can be, months to years to get through that process. So
Yeah.
just wanted
Yeah,
to note that.
I think we'd rather do that with the finalized site plan that the city approves. We go through the process once instead of starting it. Someone submits a site plan, a revised grading plan, we start, stop kind of thing. So
I
like
agree,
the
and it
first
seems that
condition.
Marion agrees with that too for planning. Good. All right.
Okay.
3.
There was one of the conditions just noting about maintenance information and guarantees for the restoration work within the wetland buffer. I think the owner's just looking for maybe some additional information on what that really entails, so they can, start looking into that. I don't know if there's any additional information that can be provided.
Typically the way that this works is that there's a landscape plan that information would be included on for development. So in this particular case, my recommendation would be that the new NRPP include a planting guarantee of 3 years, so that it allows for time for the plants to be established. That NRPP might be superseded by future development if that occurs within that time frame, but the goal is to make sure that the plants get established. So the owner would be responsible for seeding and then making sure that it gets reseeded if it fails, basically.
And this, I don't know, we can discuss this after tonight too, but I guess, is there any more information as far as frequency, as far as inspections and how that would?
Annual inspection.
Yeah, annual.
Yeah.
Okay. Okay. No, that's helpful. So thank you for that. And then the last one, I think Marion touched on it again already, was the permanent boundary, essentially, after the work is done, after the silt fence, the construction fence is removed. Is there some opportunity to work with staff on what really can go there that's, that works the best for this type of site condition, but also is economical for the owner?
You mean, now could you just clarify when you say what can go there, I mean, what kind of development?
More just
What are you looking for?
the permanent boundary refers to the condition says shall place boulders, fencing, or other permanent boundary in such a way that the wetland buffer cannot be encroached upon or mowed after completion of restoration. First of all, there's no intention. Everything's no mow here. There isn't any need really to mow given the site's condition at this point.
Right.
And then as far as you can see all the jagged vertices there, to lay out a fence or boulders or anything else around the entire peninsula shape, if you will, it's a lot of material, and it's not cheap. So,
Right,
we
exactly.
just, I think the Foxland ownership would just appreciate the opportunity to work with staff on what honestly makes the most sense for this.
Thoughts on that?
Yeah, I think off the top of my head, I would probably require that the site be fixed and have that be the simplest approach in the short term to protect all of it.
Silt fence or fence? Like actual fence, because that's big bucks.
Yeah. not silt fence.
I mean, if there's some other way that we can work with staff in terms of some sort of guarantee as part of the landscape guarantee and annual inspection, if we're not going to be mowing or touching any of the remainder site,
Right.
really no one should be out there.
Mhm.
So, something like that.
Mr. City Engineer?
Would possibly like T-post with just a little short sign, do not mow inside this area or something like that, and just put that around. That would be sufficient, I would think.
Okay.
Yeah, we can work with them on,
Cheap for you too, again.
yeah, that and location. And
That'd be
we
real-
also don't want to install, 10,000 linear feet of fencing that
No.
ends up getting removed.
You could
And
just T-post
Right.
with a little
yeah,
brief sign on each one.
okay.
No mowing and I think no pesticide application, or herbicide rather, application.
And we can lay that out in the landscaping plan.
Thank you.
Great.
Mr. Haley?
Thank you. Just so we're on the same page, establishment of the native seeds and planting will probably require mowing in that first 3 years. That's one of the ways of controlling
Okay.
weeds, so that eyes wide open, the mowing would need to cease after establishment period. So they are going to need to be in there with machineries and possibly even some herbicides. But that's all part of the establishment of the native plantings. So once
Okay.
they're done with that after 3 years and the city signs off, that's when permanent fencing or posts could be implemented.
Hopefully that is after the site develops. We have
Hopefully,
a
right.
permanent,
Yeah, that's the-
permanent state for everything. and then
Agreed.
we can work it out
3
that way.
years.
Right, agreed. Anything else at this point before we go to the public hearing?
That's all I had.
Yeah, same.
This is a notice of public hearing for the Plan Commission meeting of Thursday, July 18th, 2024 at 6 o'clock PM. In the Common Council Chambers at Franklin City Hall, 9229 West Loomis Road, for a proposal by John Spitz, Fox Glen Center LLC, regarding property at 11027 South 27th Street and 0 West South County Line Road, Plan Development District 39, tax key numbers 978-9998000 and 978-9999001. The requested special exception to natural resource special feature provisions for the purpose of impacting floodplain, wetland setback, and wetland buffer. The applicant proposes restoration of unpermitted impacts to approximately 51,500 square feet of wetland setback and buffer on the property, and requests approval of impacts to floodplain. This public hearing is being held pursuant to the requirements of 15-90110, applications for special exception to natural resource features provisions, and section 15-100208, special exception to natural resource feature provisions of the City of Franklin Unified Development Ordinance. A map showing the property affected, full legal description, and the application and all supporting materials are available for review and may be obtained from City Council by way of request to the Department of City Development, same address. The public is invited to attend the public hearing and provide input.
Okay, it's 6:38 PM. I'd like to open up the public hearing. Anyone wishing to speak at this time, please approach the podium, state your name and address for the record. Going once, twice. Oh, you're waiting right to the end. There you go. Good evening, sir. Welcome. Just state your name and address for the record, please.
Live at 31-5. Highland. Don, you out there already? Aren't you out there? Dealing with the problem across the board from this. He had a 1-month permit to fill in that pond. What did he do? He didn't do what he was supposed to do. He was supposed to level that and seed it. What he did was he put in, it was all the dirt from Layton when they were Layton. He dumped it. These guys are the guys that are to get stuck with that mess. Your people just came over and picked up a coach that somebody dumped off. We've been up with this for people dump stuff there because it looks like a dump. And they think it's a dump. and they
Agreed.
Dump stuff out.
Terrible.
Well, then we came to you. We came to your office. My back shed was flooded. The guy, and John Spitz doesn't deserve any, no permits, no extensions, If he's selling to these guys, they should know what they're getting into. It's a mess. Over there. All that stuff that's over there, they didn't even have a permit to dump all that. It's terrible.
Yep.
Got a lawnmower that doesn't work anymore because it was underwater. Flooded one of my sheds. Had a chipper shredder that no longer works because he flooded my shed. He's had 4 years. 4 years to clean this up. He's done nothing. And it's his responsibility. Not these poor guys. They're gonna get stuck with it. And it's a mess. I said what I need.
Thank you. Anyone else? Good evening.
I live exactly where they filled 2 stories high. I used to be able to look across the field, see all the way across and watch the derby. Retired about 2 weeks after I started filling that. I called you, both putting all of 27th, or all of Layton Avenue, 27th Street, Loomis Road, all the concrete, all the blacktop. Nobody would do anything, nobody would listen. I've been retired for the last 4 years. All I can do is look at the 2 stories of concrete. Can't even see past the road. No one will do nothing about it. I blame you guys. He got away with what he could, and he knew he could get away with it. These roads for all southeastern Wisconsin, you guys let him put it there. That's all I have to say.
And gentlemen, you can respond back when citizen comment period is closed to any questions or comments or concerns.
Yeah,
I can respond too.
and my wife wants to know when it's gonna be removed, because it should have been gone 4 years. I won't give you that answer, when it's gonna be removed.
I can't answer it right now, obviously.
Yeah, and now our land is definitely flooded, because the water runs across the road, I got pictures. You know, the water running across the road. Never did before. We get a lot of pictures. Yeah, we have lots of pictures. We have pictures of when they went and drained that pond, that thousands of fish just flip around on the ground until they dry it out. It's just unbelievable what they've
Well,
done.
to clarify something, sir, it is terrible. It sounds terrible. I agree. We want this cleaned up. We want it done right. Hearing tonight for the first time that there were complaints come in, I would like to find out from our staff what was done when citizens provide and come here and put complaints in. If there was illegal dumping, was there accountability? What was done with it? Because we absolutely do not want a bunch of crap put in our community and also make everything look terrible. We don't want that. Now, I'm not going to agree with everything you're stating because I don't know that to be fact. But if what you're saying is true, there has to be accountability on our end as well.
I couldn't make this.
Oh, I'm not saying you are. I'm just saying I've got to put that caveat out there.
Been me. I met with you a few times.
Mr. Moore is our city engineer, sir.
Yes, sir.
Well, thank you. My retirement.
Understand.
Oh, I understand. 100%. It's a beautiful area. I want to keep it that way.
Put on in front of his house. Put a line in front of his house. What? Yeah, no one here would want this in front of your house.
Hold on.
Our houses
This
are-
gentleman's got the floor.
Our houses are constantly covered in dust. Because it's all concrete and blacktop. They're covered in dust.
And if there's illegal dumping going on, there'll be accountability. Okay,
Yeah,
staff
that's
is made aware of it.
That's just people coming from Oak Creek and on their couches and their stoves, whatever, but it happens in a couple weeks.
Well, hopefully, this will start the cleanup and the improvement of this area.
Yeah, they just got the couch out yesterday. We thought, oh, they're covering their backs. We don't know. We gave up on Franklin. Absolutely gave up.
Never give up on Franklin, sir. Anyone else wishing to speak at this time for the hearing? Seeing no one, we will close at 6:45 PM. First comment back is City Engineer, Mr. Morrow.
Yeah. So, no, don't disagree with any of the comments that were recently made. I want to publicly thank the planning department for all the effort that's gone through to try to make this happen. I can tell you that, we were aware of complaints. We had to work within rules and regulations, how we could enforce it. This has been a cluster from day one. I admit that. It's just trying to bring this into compliance. I will tell you that what you see before you tonight is really the path out. We've been working long and hard. The state's been involved, DNR. We had the warden out assisting with meetings and so forth. And, that we've helped the DNR on their issues. They've helped us on our issues. But I will tell you that this is really the best way to make this happen. And I'm not going to say that the city broke any rules to make this happen, but we sure had to put our thinking hats on how to work within the rules so that we could provide an opportunity so a developer could come in and actually get this all cleaned up and once and for all. So we admit it's been a nightmare from day one. We've been struggling with it downstairs. And yes, I met with you and fully appreciate the issues. We've had our DPW out to clean up stuff, and when mud washes across the road, we had to clean that up. And we've had our enforcement issues. We just there's really so much we can do without going to this process. So it went to court. We've gone through the processes, and this is really the best way to make this happen. So hope you can appreciate that. If you could sit patient for another couple months, I don't know what time frame is. You might talk about the time frame for getting all this done. But the fact is, we have a developer on the hook that's willing to step up. They fully appreciate all the issues. We haven't sugarcoated anything. We've made it very clear on what kinds of issues they're facing. All the things you heard the planning department talk about tonight is not easy. There's a lot of hoops they're having to jump through to make this happen. You start involving FEMA, DNR, and of course all the city regulations and our self-imposed strict environmental regulations. It's not an easy task, and they're willing to step up and do it. I do appreciate the development that's looking to do that. So I just want to put that on the record there.
Thank you, Mr. Morrow. Comments? Gentlemen, if anything you want to respond back to?
Sure, yeah, I can add a few more things to this. As part of the scope for this, and this is kind of more of a grander scale than what you just see on here, but I guess that grading right there does show some of those stockpile areas being regraded and essentially removed. So that will bring down that visual looking to the north. Also, as part of this, a lot of the impervious area, the gravel will be removed. It'll be seeded. That should all get stabilized. So again, that will help with the runoff situation as well. So it's more than just the wetland buffer work that we've been discussing tonight. That's a part of this.
Thank you. Is there a motion?
A motion to recommend approval of the Fox Glen Natural Resource Features Special Exception pursuant to the standards, findings, and decision recommended by the Plan Commission and Common Council with consideration of the Environmental Commission recommendations.
So moved.
Second.
We have a first and a second. All those in favor?
Aye.
Aye. Mayor, do I have to say it every time? Sure. Aye. Mayor's voting aye. So that's 4 people voting aye, no nays. Motion carries. Thank you very much.
Thank you.
So moving on to D as in David, citizen comment period. Any citizens wish to approach and discuss any of the future matters under E as in Edward business matters? There are 2. Please come up, state your name and address for the record, please. If you do hold an elected position with the city of Franklin, please state that as well. Good evening.
Good evening, Alderwoman Michelle Eichmann, that is 287 West Boston, Franklin. I am here this evening to show my support for item jobs residents located within my district, the 25 South. I have been out to this property, as we have been as well. The fence is completed, it is all down and not only for the property owner, their children, child. However, neighbors, they have little children that live next door to them. Anyone going down, access, get into the yard. One end of the pool is this county. And I am hoping that we can just approve this evening, so forward in council. I would not be able to let if it's been encouraged with the process that today and forward to the staff. Thank you.
Thank you. Seeing no one else, I will close citizen comment period. And let's move on to E as in Edward 1, Housing Affordability Report, 2021-2023, presentation by City Development staff. This would be Mr. Martinez.
Thank you. First, I would like to thank all Department of City Development staff, Marion, Principal Planner X, help with the vacancy rates analysis that you have in the report. Associate Planner Hamill helped to prepare all the maps and list of that's required by Wisconsin statutes. And Planning Intern Serna helped to get all the data for lots platted and how many building permits were issued during the reporting period. So this is a report that is a requirement by Wisconsin statutes, the Housing Affordability Report, and the statute sets what is the contents of the report. So first is an update on the implementation of the city's comprehensive master plan, specifically the housing element. And also the statute set a list of data that the report should include, and we will jump into that. The requirement by the state is that the report should be posted on the city's website. That has been done. And we're doing this presentation kind of an optional to provide the Plan Commission with additional information to go beyond the requirement, but it's not required to present this before the Plan Commission. For this report, it's a multi-year report. State requires that this should be presented every year. However, in the previous 2 years, that was not completed due to staff shortages and the vacancy of the planning manager. So for this report, we're providing the previous years also and to comply with the requirement. So first, I will go to the implementation of the comprehensive master plan. So the master plan has 15 recommendations on housing. You have all the recommendations on the report and an analysis, but for the presentation, I will only go to a select number of recommendations. So first is the principal goals and objective and policies. So what the recommendation of the company is to update the comprehensive plan and the housing element every 5 to 10 years. That has not been done. The plan was adopted in 2009, so we are overdue on the update to the comprehensive plan. So staff recommends as soon as possible to update the comprehensive plan. This is already overdue. This report also includes an analysis of the changes, potential changes with the UDO rewrite project that has been presented to the Plan Commission. So we're also analyzing how this new ordinance will affect the housing affordability and will affect also the implementation of the housing element of the comprehensive plan. So one of the recommendations, it's about single-family residential zoning to retain this single-family zoning as the predominant type of residential development in the city. So in the presentation and the report, there is an analysis of what changes of the UDO may affect this recommendation. So we identified 3 major changes. Duplex homes will now be a conditional use in some single-family residential districts. Currently, that's not allowed. There the UDO has also a standard for townhomes. That's a new type that is being in the UDO draft that is not in the current draft, in the current ordinance. And also the accessory dwelling units like in-law suites or granny flats, as people call. The internal ADU, that will be a permitted use in all single-family residential districts. So that will incentivize the housing supply. And also the attached or detached ADU will be a conditional use in all residential districts. For mixed-use development, we'd like to clarify that the current ordinance allow for vertical mixed use, like a commercial building that has ground floor, retail, and apartments in the upper floors. That's allowed in all business districts, and that standard will remain with the new Unified Development Ordinance.
Mr. City Attorney has a comment.
Fine townhouse.
The townhomes, that's defined in the UDO. That's basically there are not detached. So you can have townhomes like attached side by side. That's the basic definition. So there's no side setback. They are attached side by side.
So it's single-family homes abutting each other.
Shared wall.
Right. Yeah. For example, the
His mic's not on, by the way.
the project that we reviewed like a month ago, the Safari Homes,
Oh my,
that was kind of a townhome concept. Okay.
thanks.
Yep. You're welcome.
Differentiate, if you would, then, between.
Mr. Haley.
Thank you. Between a duplex and a townhouse?
At the townhome, maybe multiple, more than two that are attached side by side, while the duplex is just two.
Thank you.
Duplex is vertical.
So,
No?
so another change with the new Unified Development Ordinance is that cluster or open space subdivisions, like this example that will allow for smaller lots while preserving natural resources. Now that requires a special use permit. With the draft, we're proposing to eliminate that requirement. So that in order to streamline the process for these type of subdivisions. Multifamily development. We will also proposing to eliminate the special use requirement to streamline the process for multifamily development projects. That will still be reviewed by the Plan Commission by the way of the site plan process, but it will be a shorter process that it doesn't require a public hearing and it doesn't require to go before the Common Council. Okay, so that's the first part that talks about the recommendations of the comprehensive plan, the housing element. So next we jump into the information that is required by state statutes. I will not go through all the information that is required, just selection. So first, it requires a map and list of parcels that are zone residential, but are vacant. So this is possible site for future residential development. So this is the map, the results. It was prepared by Planner Hamill. As we can see that most of them are kind of the west, southwest area of the city. And then we provide a full list in the report. The other map that is required is to identify parcels that have potential for residential development, but are not zoned for residential. So we look for properties that are designated as residential in the future land use map. So most of them are in the south area of the city. But the problem is that most of these parcels are far from existing public services like water and sewer. Okay. This table here, it's an analysis of the single family housing, lots platted, and building permits issued. So the process works that subdivider come and present a plat application, goes to Plan Commission, hopefully gets approved, and then the same year or the following year, they apply for getting all the building permits. So when we look at historical data, like this period here between 2009 and 2012, there were no lots platted because of the economic crisis. So if we look, for example, at this period here between 2015 and 2020, we can see that the kind of the platted start to kick again, like recover from that period. And then after that, we see an increase of building permits issued. So lots get platted and later the building permits get issued. So, and that gives a kind of a picture of the housing supply. So for the reporting period here, so we have it here and we have the kind of the average here. So what it shows is that you can see in the average here below, that the amount of lots platted, it's slightly under, like we have 58, the yearly average of lots platted, but 65, the average of building permits issued. That suggests that kind of the city is not keeping up with the demand for new housing because it's platting less than it's building, okay? That's for single family. But when we add the multifamily to kind of to get the full image of single family and multifamily, so we have here the multifamily, right, and the single family that we saw in the previous table. And here will be the total. So for multifamily, it kind of follows the same process. Projects gets before the Plan Commission, like for a special use permit, then gets approved, then the following year, they start applying for building permits. So that's why we have dwelling units approved or platted, and then actually what is constructed, right? Okay. So we have the data here in the reporting period. So we saw a great increase in dwelling units approved for multifamily. We have 0 in 2021, and then 252 and 500 in 22 and 2023. We can see here that gets reflected in the amount of dwelling unit or apartments that were built. So we have 230 here. Most of them that was approved the previous year. So then when we look at the total, then what the cities have been approving for dwelling units total, multi and single family, is more than what is being constructed. So this table shows kind of the opposite of this previous table. In this case, then the city is keeping up with the demand for dwelling units as a whole, single family and multi-family. Then the state statute also required to kind of provide a forecast of the housing demand and housing supply. So staff use what is the household population projections by the Wisconsin Department of Administration up to 2040. Okay, so they project a population for the city, household population, does not include like correctional facilities, of 42,000, right, 922. Then they have also projected persons per household, about 2.3 persons per household. So that's give the number of households, right? Then we subtract that from what we have in 2010, and then we get the new household from 2010 to 2040 that will be kind of coming to the city according to the population projections of the Department of Administration. Then we add a 5% kind of the vacancy rate to kind of provide for that kind of that caution, right? And that will be, the result is kind of the new housing units that are needed to accommodate the projected population. So we compare that to the historical building permit data that we show, and then we took the yearly average and kind of project that to the upcoming years. That's a kind of, we assume like a linear projection, right? That may vary. We don't know what will happen in the future, but that's kind of an estimation. So assuming that yearly average, so the number of dwelling units that will be constructed up by 2040 will be 4,239 dwelling units, so, which is less that will be required according to the population projections. So in that case, to conclude, we kind of recommend some changes. Sorry, I don't know what happened to the screen here, but I will explain that. That what recommendations are we made to kind of help to incentivize the housing demand. So we have 3 reasons that was identified in a report by a professor of urban planning that kind of start all this housing affordability. So first was not building enough homes. So as we saw in the projection, if the rate that we have at this moment will continue, then we will not meet the population projection. So in order to address that, we're recommending the Unified Development Ordinance rewrite that has all these changes that will kind of help to incentivize the housing demand. And also, cannot see here, it's also, as I mentioned at the beginning of the presentation, to update the comprehensive plan and also to adopt kind of a traditional neighborhood development ordinance. That's also recommended in the comprehensive plan that would allow for more compact housing and that will allow for greater densities. But we'll have a separate presentation for that in another session. That's all about the housing report. Happy to answer any questions that you may have or provide additional information.
Well done. Any commission questions at this time? Seeing none, is there a motion?
The motion will be to accept and place on file.
Excellent. Motion to accept and place on file?
So moved.
Second.
First and a second. Mayor will be voting. All those in favor?
Aye.
Aye.
Aye. No opposed, motion carries. Well done. Moving on to item E2. Cindy Dawes miscellaneous request for approval to allow for the installation of a fence within the 20-foot private planting screen upon lot 12 in block 1 of the Tuckaway Green subdivision on property located at 7524 South 77th Street. Tax key number 7920012. 000. Short version, Mr. Martinez.
Thank you. This is the location of the property. It's about in 76th Street. So for this subdivision, all these lots have what is called in the subdivision a planting screen that is 20 foot wide. So typically structures like fences may be permitted in the planting screen, but requires approval by the Common Council. So the applicant submitted the application. It's for a 6-foot high vinyl fence, kind of to comply with the building code requirements to kind of enclose the pool area. This is a picture of the existing fence, and this new fence kind of to replace this fence. This existing fence, there's no permit on record, so that's why it's not considered a legal nonconformity. So any replacement needs to comply with all the requirements and go through the approval process, just as a new fence. The current language that we have in the landscape buffer yard easement says that fences are allowed, but require the approval of the Common Council. So for that reason, this is consistent with the current language for this kind of easements, staff is recommending approval of this application, and it has to go to the Plan Commission in the following meeting. Sorry, to the Common Council.
To the Common Council, yes. So staff recommends it. I'll start. Full disclosure, I know Mrs. Dawes. I know the Dawes family. Mrs. Dawes is my campaign treasurer. I have seen this dilapidated, falling down, it looks terrible. To Alderwoman Eichmann's point, there is a lot of children in this neighborhood. They've got 6 children, a grandchild. There's a lot going on there, a lot of neighbors, a lot of very young children running in this thing. This should have been done, and this is not on you, this should have been done long ago. They are ready to roll with this. I fully support it. And if there's any other questions, looking for a motion? Any other comments from the fellow commissioners? Seeing none, is there a motion on this?
A motion to recommend approval of a resolution authorizing the installation of a fence within the 20-foot private plat restriction upon Lot 12 in Block 1 in Chocaway Green subdivision.
Mayor will be voting. Is there a motion? First and a second. All those in favor? Aye. Any opposed? Ayes have it. Motion carries. Motion to adjourn. Mayor will be voting. All those in favor?
Aye.
Aye. Motion carries. We are off the record at